One of the questions that we're often asked is, how long do I have to file a lawsuit? The answer is a typical attorney answer. Well, that depends. It depends on where your injury or where your incident of malpractice occurred. In the District of Columbia, they have specific statutes of limitations that mandate when you have to file your case by, and if you don't file it by that deadline, your case is forever lost. It will be time barred under the statute of limitations. In the District of Columbia, there is a 2-year statute of limitations for the death of somebody. If there is a wrongful death claim, if your loved one has lost somebody to either medical negligence, a car accident, whatever it may be, you have a 2-year statute of limitations to file that claim for wrongful death. Now, if the individual did not die, and let's say an individual suffered an event, a malpractice event at a local District of Columbia hospital. In that case, the injured individual would have 3 years from the time of the malpractice until the time that he has to file suit. So you would calculate 3 years from the date the malpractice occurred, and you must file your medical malpractice suit or your personal injury suit within that 3-year period. The exception to that is minors. Minors in the District of Columbia have 3 years from their 18th birthday to file a lawsuit. So if you or you believe your child may have been injured at birth, if your child is a teenager, you can still investigate and bring that claim. There is a 21-year statute of limitation in the District of Columbia for injuries that happen to a minor while that person is a minor. Their clock doesn't start ticking under the statute of limitations until they turn 18. And the moment they have turned 18, they have 3 years from that date to file a lawsuit.